regarding certain specific laws that regulate the security of processes in IT and the security of products in IT, to then provide a few comments and perspectives that are purely my own, of course. Just a brief context for those of you not familiar with the European Union. I don't know, it's an international organization of 27 member states, of which the law is supranational. It means it's an international organization. It's not a country, but if there's EU law on a certain matter, which is focused on only the internal market, but if there is law on the matter, it supersedes national law. More particularly, there are two types of secondary EU law that will be important. The treaties provide a constitutional basis, but for them, you have a regulation and a directive. Regulations, they replace national law immediately. They immediately take full effect within the country's law, whereas a directive is essentially the EU saying to a country, provide me a law with X and X and X specs, and they are still free to choose the means on how to implement it within a certain deadline. I mention this because it will be relevant later on when discussing the laws in particular. So first of all, why is the EU regulating cybersecurity law? Well, I think the most obvious answer is that because the risk for cyber attacks has been increasing along with the digitalization of our society. And hence the need was identified to increase cybersecurity within the European Union across all parts of the supply chain. That means the manufacturer, the professional user, the end user. And because they're on the rise, why do they want that? They want, well, from the cybersecurity strategy for the like they say it's for resilience, to maintain resilience against attacks, to maintain technological sovereignty and leadership. So in other words, to be ourselves when it comes to digital side, to build an operational capacity, and to preserve a global and open cyberspace. How do they do that? Well, I think this AI-generated slide says it all. Laws, lots of laws. I'm sorry, I have a lot of slides. It's not because I cannot be concise. It's because of the sheer amount of laws. Here's a little overview. So, for example, we had the GDPR in 2016, which is Turkish equivalent to KVKK, with the NIS1 directive, and then further and further it became more and more refined with some sectoral acts like for e-identification, radio equipment, the NIS2 directive, but then further updates with the NIS2 directive, Digital Operational Resilience Act for the financial sector, Cyber Resilience Act, the EU Institutions Cybersecurity Regulation, the Artificial Intelligence Act, and so on and so forth. And as you can see, it just keeps on going, and new laws keep coming. And this might sound like an entire quagmire, but the good thing is they actually all express the same principle, which is security by design. It was first expressed in the Cybersecurity Act, which creates a voluntary certification scheme in 2 recitals. And ultimately what it says is any digital product, any digital service, or any digital process has to be secure by design. That means that from the very beginning of the ideation phase to the end of the software lifecycle, it's built in such a way that it protects itself against cyber attacks, that the risk of cyber attacks is minimized and mitigated, that policies are in place to mitigate it when it occurs, and that it is, second principle, by default, that it's a default setting that is intuitive to the user, that it doesn't require a lot of technical skills. Why? Because cybersecurity is a holistic endeavor, so everyone needs to be able to provide a level of security for themselves. Over the past few years, these many laws that I've seen are actually just expressions of this principle into hard law. And they all have a similar structure. So what they will require is they will require risk appropriate, not perfect all the time, but appropriate to the risks of the data or the resources you have, security measures regarding risk management, like authentication or reporting of any particular incidents, where the details are actually not filled in by the laws. You can prove your compliance through compliance with technical standards. So private documents, copyrighted documents that are set up by industry ultimately, and then approved of by governments in some cases, and you can use those to prove compliance. And those laws are then enforced by an independent regulatory agency that can provide injunctions, warnings, but also can provide, well, pretty infamously since the GDPR, administrative fines that have to go up to a certain percentage of the worldwide group turnover, or a corresponding amount expressed in millions of euros, whichever is higher. Now, as I said, there are 2 types of these laws. There are 2 sub-differences within this common structure, which is one type of laws like the GDPR, the NIS2 directive, and the Digital Operational Resilience Act. I'll talk about the former 2. They provide process. That means they provide open measures. They describe measures you need to take. They keep them open, and standards, you can just use them as proof of compliance. More than that is. The second, however, is that cybersecurity, along with fundamental rights, are being introduced into the product safety framework, which means that they will require certification of products where the standard compliance actually creates a presumption of conformity without which you cannot go to market, which I will explain later how that works. So now, security of processes. First of all, we already had the GDPR before the Cybersecurity Act. And what that ultimately does, it already has some security measures. For example, a controller or process, the controller is who decides to process personal data about a person, or that you can identify a person from, or that you can say something about that person. You have to keep it clean. You have to keep it secure. There are principles that, for example, you have to only use it for certain purposes, minimize the data onto what is necessary for that purpose, only store it as long as it is necessary for that purpose, remove it once it is no longer, and restrict it, thus actually also reducing the attack surface. Also, cybersecurity, however, does give you a legitimate interest to process personal data. Let's say, for example, to prevent cyber attacks, you have the right, for example, to identify certain IP addresses or certain malicious users for this purpose, except, however, some sensitive data that are problematic. What are we talking about? Sensitive data that can reveal political orientation, sexual orientation, genetic data, health data, and the likes. Another particular case is biometric identification.
Maybe I may chime in here, maybe
Sure.
about these principles, right? These questions, maybe I should turn this on or not. I'm going to directly ask you.
Yeah.
I mean, these principles like data minimization, etc. How important is it to notify the end users of internet about these principles are being upheld by the EU law? I mean, when I'm entering into a new website, I'm being informed about this. And how central is this in GDPR?
The GDPR does require this. So ultimately, I didn't mention it here because it's not strictly to cybersecurity, but ultimately the controller has to inform a data subject when they collect personal data from them about the purposes they're using, about the legal basis they're using. And those purposes, they also then a regulator can also control whether or not they only used the data for this purpose. For example, I could use, well, stupid example, I can detect attackers. I could, for example, check IP addresses and which URLs a certain machine is looking to see if there's viruses. But I can also use that to see what an employee is doing on the job. Or I can do that to try and infer what that person likes for additional purposes. That's where purpose limitation comes in, for example.
Sorry for this.
No worries. So I'll go with that. One particular one, however, is the biometric identification. Why? Because biometrics, this is facial patterns, but can also include mouse movements, keyboards, keystroke patterns, and the like. You can not use legitimate interest for identification. You can, however, use it for authentication to identify whether someone is what they claim to be, which creates the need for anonymization. It's a very thin scope, but this is what the law so far provides. Also, controllers must provide security for their networks, notify any leaking of the breaches of data, and do a data protection impact assessment for certain higher types of processing, thus already providing some level of security that they have to preserve into their own processing. Of course, the GDPR is the one that pioneered the oversight in regulators with fines of turnover. I believe with the audience, based on the reaction of the audience, I think this is no. A second interesting law is, of course, the Cybersecurity Act itself. It expresses the principle of security by design away from personal data. So the data doesn't have to be personal for it. But it doesn't create any hard laws. It creates a framework for certification schemes that are either basic, substantial, or high based on the expected level of expertise of the attacker. And the presumption is that when you certify under one of these schemes, you are presumed to be in accordance with that scheme, which means that you have a certain level of cyber maturity, which can then be linked to hard law, which I will get to later. And I give you an overview of the currently applicable cybersecurity certification schemes. That leads me to the final part on process design that I will discuss, which is the NIS2 directive. I repeat, directive, and it is a minimum harmonization directive, which means that member states are allowed to be stricter than the baseline set by NIS2. It is also not fully transposed. I'm from Belgium. I'm lucky in that sense. Normally, we are very late. Belgium was the first to fully transpose it. What it does is expands on a previous law by requiring more sectors, providing a harmonized baseline of measures and a baseline of enforcement. How does it work? Well, what it does is, the NIS2 directive does in terms of scope, it divides certain sectors it divides entities into essential entities and important entities. And essential entities, there are some categories of entities that are regardless of size, but usually it's medium-sized, which means 50 staff, I think 10 million euro turnover. There is a recommendation that provides these thresholds, and whose main activity is within a certain sector. And when you're in that, then you are an essential entity you have to fee measure. If you are not essential, but you're still within this sector or another sector, then you're considered an important entity, which means they have to take certain measures. The only difference is in the supervision. Essential entities, the government can go by their own motion. Important entities, someone has to complain first before they go after them. I give an overview of the sectors, what type of sectors we're talking about, the usual suspects: energy, transport, banking, financial market infrastructure, health providers, drink water, wastewater, digital infrastructure, including social media, IT service management, public administration at the central or equivalent regional level, space infrastructure. For important sectors would be mail, waste, manufacturing was added, production of food was added, digital providers were already there, and research organizations were also recently added, which is an expansion of the type of measures they have to take. Now, what do they have to do? Well, taking into account the risks, again, very open, you have to kind of see what is applicable to your use case. You have to take a baseline of all hazards risk management measures that they just have to take. And the board has to be trained in cybersecurity and has to be aware of this, and this has to show a certain level of maturity and knowledge themselves. What type of measures are we talking about? We're talking about having a policy, having incident handling, supply chain security, checking your software and hardware vendors to see whether their products are secure or services are secure, having basic cyber hygiene practices, having human resources policies, also using multi-factor authentication and the like, that these measures are in place to ensure that an organization within their internal processes is protected against attacks. Also, the NIS2 directive creates a 3-tiered reporting of significant incidents. Significant incidents are incidents that meet a threshold of operational disruption within a critical sector or essential sector. There is a guideline, there are thresholds within an implementing regulation by the Commission, published last year. And why do I say 3 tiers? Because every notification has to go in 3 steps. Within 24 hours of getting aware of an incident, there has to be an early warning to the cybersecurity authority in your country, in the EU country. Within 72 hours, a formal incident notification with an update and an initial assessment of the severity. Upon request, you need to provide intermediate reports, and a final report with the type of threat, mitigation measures, and cross-border impact that you identified needs to be filed within 1 month, which are very tight measures, because often with these zero-day attacks, you do not know how long an attack has been going on, and sometimes it might be difficult to recover those tracks. So this is process design. Process design, by which I mean ultimately you have businesses that within their processes have to do something all the time, and that an auditor can come and check you. What is innovative by the EU, this is an innovation, is security by design of products. And I believe within the audience, the symbol that I now show is familiar to most. It's the CE marking that shows that a product is safe to be marketed in the European Union. And that is actually the innovation by the EU. The EU is now introducing cybersecurity and software into the new legislative framework, or product safety law. And what it is actually, it's a set of laws, a lot of them, although you can see them on the left, that regulate the safety of products by requiring them to meet, they're designed to meet certain essential safety requirements before being placed on the market, where conformity with those laws is presumed when you certify them according to an EU harmonized standard. That's usually an ISO standard that is requested by the commit, that is developed by, well, European standardization organizations. Actually, it's an EN standard that usually is based on ISO, but the Commission orders and approves and publishes the reference to in the official journal. When you comply with that standard, when you test and certify under that standard, you are presumed to be okay. You think you're going to be okay. It's rebuttable, but you think you're going to be okay. The law will require a certain conformity assessment procedure. Depending on the risk associated with that product, the manufacturer can certify themselves. They can say, we did a good job. We followed our tests. This is our results, and there's fine. Some products you will require a third-party entity, like a TÜV suit, test that run the product on a test bench, and they provide the certificates that this can be put to market, which of course costs a lot of money, but might help that people don't just pat themselves on the back. Where, of course, afterwards, the manufacturer also has to monitor what's happening, and market surveillance authorities will also conduct surveillance, which means that, and by post-market monitoring, that might result in corrective measures, such as, for example, patching a product, but also a recall of the product, removing it from circulation. First of all, what the EU did is they added, normally the scope of product laws was only hardware. So software could only be regulated if it was embedded in a hardware product, not in its non-embedded shape. That's been changing. So under the medical devices regulation for devices used in diagnostics, this was already the case since 2021 with the 2017 regulation that became applicable in 21. AI Act and Cyber Resilience Act also provide rules that are applicable to software in their non-embedded shape. Under the Product Liability Directive, software products also include non-embedded software. Also, cybersecurity features are now added to regulate the design of what is safe, by which I mean that, for example, General Product Safety Regulation provides this, that you consider safety by looking at the cybersecurity features and the AI features. And the Medical Devices Regulation, AI Act, Cyber Resilience Act, they also elucidate certain cybersecurity features that need to be built in for safety. Another also, for example, the Radio Equipment Directive with the Commission Delegated Regulation also covers IoT devices. Radio devices are anything with an antenna, and it's clarified anything that goes over Wi-Fi also counts. What I haven't mentioned on this slide, but is also important, is that the concept of security and safety is being stretched. Why? Because with the AI Act, as I will discuss later, previously the concept of safety was my machine cannot harm you, cannot harm a human. And security was my machine cannot be harmed by an attacker. But because you have hardware products where cyber attacks can cause physical harm, cybersecurity becomes part of the safety. A machine that gets hacked can hurt you. A car that gets hacked can cause an accident. But also with the AI Act, risk of fundamental rights. Facial recognition software can discriminate against certain people of certain ethnicities. And that harm is also being certified and pushed into this technocratic product safety framework. I'll now discuss the two main acts, which are still partially upcoming. They haven't fully become applicable yet. I'll talk about the Artificial Intelligence Act and the Cyber Resilience Act. So here's where we are with the Artificial Intelligence Act. It was adopted in July 25. In July 20, yeah, no, sorry, last year, and then in 24, sorry, in the summer of 24. And right now, the general provisions and the prohibited AI practices are applicable, as well as we have passed where the notified authorities should have been there. There should have been an EU database. There are penalties, and the rules on general purpose AI are applicable. Most institutes are not yet there. So we'll move the deadline later. And normally next year, we would have to have certification of high-risk AI systems with the presumption of conformity. I'll explain in a bit why that is later. What's its scope? It's any artificial intelligence system. What is that? It's a machine-based system that is autonomous, acts without human intervention, and is adaptive. It can adapt to its circumstances, inferring outputs from inputs that can influence the real world, like a decision, an inference, a suggestion, an action. Applies when it is either placed on the market or put into important professional use. However, some aspects of AI are excluded. For example, AI used for national defense is excluded because the EU is not a national defense organization. It's an economic.
Laws are not included in this. Lethal autonomous weapon systems or
what that means that when something is used for defense purposes, we rely on member state frameworks to certify, because the EU, and this is also relates to the competence of the European Union. The European Union started out as a customs unit. It's an economic unit. The AI Act was based on Article 114 of the TFU, which means harmonization for the internal market, not for elements that the member states are much more core to their defense or core to their state powers. I know the EU ties some stretches, but that's something they could never receive and never fully cede. Also, for example, any research and development regarding models before marketing is also not applicable. So basically, when you're just doing research on a model, but you're not going to release it on the market, then you are really fine. Also, anything within a purely non-professional activity. So for example, if as a hobbyist, I develop an AI system, the AI Act will not apply to that. Mm-hmm. Now, who is subjected to AI? Well, there are the following potential actors. It's both private and public. As long as the AI system is placed on the EU market or its use affects people that are located within the European Union, which is a very wide extraterritorial reach. Who has to comply with the Act? Either the provider, which is the manufacturer, the person who has the AI model developed, the importer distributor further down the chain, or the professional user. So for example, if the university were to use an AI model, they would be professional user. If I just use it for funsies, that wouldn't apply to me. The AI Act, I say it's a product safety law. It's actually a bit of a chimera in the sense it combines a lot of different types of rules and actually a 4-tier risk system. So some AI systems, based on the purpose for which an AI system is used, it's intended to be used, are considered unacceptable and their use is simply banned. For cybersecurity requirement, for some categories of AI systems, like essentially those called higher risk, I'll explain what those are in a bit, we create certification mechanisms, which include cybersecurity features. There are some transparency rules that you simply have an AI that has to say that it's an AI. And for all other rules, which actually is still the majority of AI systems on the market, there will be no rules whatsoever. Now, what type of practices are unacceptable? Manipulative AI. In Belgium, for example, there was a chatbot that manipulated a person into committing suicide. An AI that can do that, for example, that would be considered, or an AI that can manipulate you into buying or anyway causing yourself harm through subliminal manipulation or intentional deception, that would be banned. Social scoring, but not all social scoring, which means profiling where, for example, based on your behavior, you would get a certain credits, a certain social score. Also banned if the scoring has a harm that is in a different context, let's say food data that is used for life insurance, or is otherwise considered disproportionate, to be clarified with the disproportionate behavior. Or crime risk assessment, they don't want that. Untargeted scraping of faces from camera footage or internet. Emotion interference outside of medical and safety reasons, or necessary for that. Biometric categorization systems, but only some biometric categorization systems, because and in particular, real-time biometric identification in publicly accessible spaces. Note, those last two are not bans, because what happens is, some types of categorization systems are prohibited based on sensitive data, and real-time biometric identification, what the only ban that is that for real-time biometric identification in a publicly accessible space, that there needs to be an order by a judicial authority, a search warrant. Now, publicly accessible space, now it's only biometric identification, not authentication, CGDPR, and also a publicly accessible space is only a physical space. The recital clarifies it doesn't apply on the internet. It doesn't apply in cyberspace. So you can still, these AI systems can still be placed on the market. Doesn't mean they will not be certified, but they can be placed on the market. Now I'll talk about the high-risk AI systems, estimated by the Commission to be 10 to 14% of AI systems on the market. What type of AI systems are high risk? Well, it depends on the purpose for which your system is used. Either it's a safety component, that means a part of a product, composite product, without which the product cannot work or will create harm. For a product that is already regulated under the new legislative framework and undergoes third-party certification. A good textbook example would be diagnostics medical devices. Anything used for therapeutic purposes. That needs third-party certification. Any AI-powered component has to also be certified in the AI Act. It's high risk. Or there's also exclusions for railways, motor vehicles, and ships. That's more because these have their own certification frameworks. Another category is an exhaustive list, so there's no other categories of high-risk use cases. AI systems that are intended to be used for biometric identification, for critical infrastructure safety components, or for profiling students, deciding who gets admitted to a university or who gets the degree, employment evaluation, hiring evaluations, who gets emergency care, or in law enforcement, the AI-based lie detectors or risk assessment for those systems. Same for migration procedures or assistance to judges or AI systems that are otherwise used in elections. They would be high-risk use cases and subject thus to some requirements. What type of requirements? Well, this is having adequate risk assessment. So you have a policy that you check the risks. You have to make sure that the training data sets on which an AI system learns, because AI learns from data sets, that these are, of certain quality and in a way that they represent a target population. Again, you want to avoid that the AI system might falsely discriminate against the person. So you have to make sure that it represents the target population on which you're going to deploy it. There needs to be technical documentation. AI systems, to be auditable, also need to be logged. So you need record keeping. There needs to be clear, so it automatically has to log what's happening in the AI system with clear information to the user how to use it, and appropriate human oversight measures to minimize the risk, which means that a human needs to be in the loop, knowing what's going on, or sometimes needs to be able to overrule the AI system's commands. When it doesn't clarify, that's what standards will have to do, but it does that. And importantly, it also requires a high level of robustness, cybersecurity, and accuracy that the AI model itself cannot be attacked by an attacker, because you can. For example, there are cases where if you put a certain sticker on a stop sign, a self-driving car can read it as a highway sign. Or that you can evade facial recognition by wearing a certain set of glasses or wearing something on your t-shirt, that it suddenly thinks you're a different person.
Maybe I can ask a question here about robustness.
Yeah.
So robustness is actually what it is. So I can guess because of my experience in laws, but here robustness has got to do with the way it functions properly.
Yes.
And also this appropriate human oversight has got to do with different elements which are very movable, which are very fluid. So it is that I'm not saying there should be, I think there should be problem, but I'm not saying there but are there any mechanisms, safeguard mechanisms that see to the fact that the appropriate human oversight measures are there? Because human oversight, you mentioned man and human in the loop, but human in the loop or human on the loop issues are not 100% credible actually, because there is this
Exactly.
bias,
Exactly.
algorithmic bias or artificial intelligence bias. So are there any inbuilt measures, mechanisms to see that these are really, these standards are adhered to?
Well, yes, these are standards that the product will have to be certified. I will get to that. Where market surveillance authorities can control this. Now, with human oversight, I also find it's a very interesting one, because when I look at the harmonized standards for it, I don't see many standards that really provide a typology, for example, of when to use a certain level of human oversight. Because you can imagine with some of these high-risk AI systems that you can perfectly do this. You can have the AI system provide a suggestion, and this suggestion then gives the human, and a human can still say, I believe this or not. No, I'm going to do it slightly differently. Like, for example, when you use a ChatGPT prompt and you revise the answer a bit, that's possible in some cases. But in some cases, like, for example, cyber attack detection, depending on your use case, there's just so much traffic that you cannot put this on one human. It's not possible. It's like with content moderation. They have these workers in Kenya that usually get very traumatized from their job, but they also just have to keep up with the men under immense pressure. And even then, it might not be enough to have adequate human oversight of the work. So that's why AI seems to then have to assist. But indeed, it needs to be there. It's not perfect, but it's better than nothing. It is better than nothing. And with robustness, yes, but what that means is simply the AI model has to work under abuse. So I would say with robustness, let's say, for example, you have indeed a self-driving car mechanism, but then it needs to be robust in the sense that when someone wants to put a sticker on a traffic sign, which can be used ultimately in an assassination attempt, for example, that this doesn't happen, that this can be detected, or that basically in time there is a response mechanism in place.
Thank you.
Okay. What type of obligations do we have here? Well, as I mentioned, the producer mainly has to provide the conformity assessment procedure, documentation, the logs, and every substantial modification. Importer, distributor, they mostly have to verify whether the provider did this job. The deployer also has his own rules. For example, the deployer also has to have appropriate human oversight in place insofar as they can. For example, if a university decides to use, if the police department, for example, let's use university as a better example, decides to use an AI for student grading, they need to oversee that the system doesn't lead people astray. In as much as they provide data, they also have to ensure that the data is representative of the target population. There's no bias, there's no algorithmic bias fed into the system, for example, by only providing data on a certain subset of students.
I believe it happened once in terms of law enforcement agencies in the UK, if I'm not mistaken. This algorithmic bias took place in Scotland Yard. I guess they were using an AI-based or AI-enabled program, and it has started to profile people according to their racial belongings.
There were also cases of that in the United States. For example, in the United States, there are these recidivism algorithms that are actually being used today that disproportionately will give higher penalties to Black people, even for similar offenses. And it's not even closer to home, let's say. I believe some may have heard of the Dutch social affairs scandal, where social and tax authorities used an algorithm to determine who was at a higher risk of committing social fraud. Turns out the system took as a criterion people who had dual citizenship. because they were more likely to be considered by the system to be more likely to be a social part. Why? Because maybe there was bias by the researchers, by the searcher, by the authorities in the time that is simply being crystallized into the AI, and the AI doesn't know the meaning or that this criterion is not a savory one. So it just says, okay, I see a correlation, therefore I'll target these. And many people were just completely removed, destroyed their livelihoods, destroyed because of this for no reason. So yes, this does occur. Yeah. But okay, so anyways, to go over these obligations, the or also will have to inform workers' representatives prior to use of the AI system. If they're a public authority, it also needs to be registered in a database, and there needs to be a fundamental rights impact assessment. That's a type of reflection impact to actually assess these impacts on. Sorry, I might be going slightly over time. I'm sorry. Again, it's because of many laws that I have to cover, but I'll be as quick as I can.
But this presumption of conformity.
Yes.
Yeah, as far as I'm concerned, it's one of the pillars that I was actually
Exactly.
writing this down. I wanted to ask.
Exactly.
It's great that you have it here in the program. This is, for example, a important issue as far as I'm concerned. Maybe you can develop this more.
Exactly. So, of course, being a product safety instrument, the AI Act is very heavily reliant on the presumption of conformity. And again, I will repeat what does it mean is a European harmonized standard. It is a standard that the Commission orders from CEN, CENELEC, or ETSI, depending on the use case. In the AI Act is CEN and CENELEC. And they provide a technical standard that meets the requirements of certain laws. They usually take it from ISO. So usually they will take an ISO standard and make a few tweaks and make it EN ISO. And then it goes to the Commission accepts the approves of this, Commission publishes the reference in the official journal, and then everyone needs to follow the standard. Highly important, because why is this presumption of conformity? It doesn't say you are okay, because standards are still voluntary, but if you certify under a standard, the authorities will presume you're okay with the law. If you don't, you can still be okay with the law, but then you have to prove yourself that you are okay. So you can see how there's a huge pressure, in fact, to follow that established standards anyway, because it's the path of least resistance. That's why actually lately there is case law that includes these standards as part of EU law, and even recently required a disclosure against copyrights on these standards because of their importance to clarify the meaning of the law. More to be continued on that. I haven't added because it would take me too far, but it is a very important part. And when it comes to the AI Act, there's the following standards. There are standards that are being worked on, but the system that it has is you have presumption of conformity if you conform to this harmonized standard in accordance to a conformity assessment procedure. I'll get more to that later. But the problem is right now, the standardization organizations, they're working on them. They're not going to be ready in time. The working committee the group has mentioned that they will likely be able to finish by 2027, by which the high risk requirements will have been enforced for a year already, or at least half a year to a year. So that will already put a slowdown on the entry into force of the Act. And in fact, that's why it was even mentioned that we would need that there was some policymakers that said we had to simplify the AI Act, whereas ultimately the legislators said, no, we're going to stand our ground, but yes, we're going to work hard on the implementation, much like the GDPR, where in 2018, it became applicable, but it took a few years before the institutions actually came along and got up and running. Now, without these standards, can the AI Act function? Yes, it can. Some aspects, you can just look at the standards that are currently there. It's possible, but it will set up a different, and there are some subsidiary options. One is that the Commission will publish its own common specifications that simply will act as placeholders. So before there is a harmonized standard, you just follow the specification that the Commission publishes, centralizing power to the Commission, of course. Other requirements, for example, when it comes to data representativeness, if you can say, we basically only use data that specifically represents our target group, then we are okay, then we follow that requirement because then we actually thought about it, which I, of course, criticize because it's, again, patting yourself on the back. And for robustness in cybersecurity, if you certify under the Cybersecurity Act, for those risk categories, you can also enjoy the presumption of conformity. That's a stopgap measure. But for example, not all certification schemes might be covering adversarial attacks, specifically targeting AI models. This is the conformity assessment procedure. This is, I think, even more important than just the harmonized standard. How do you test these standards? Now, under the new legislative framework, there are a large set of procedures. I'll not go into full detail. The biggest distinction is that some require only self-certification. Others require third-party conformity assessment procedures where you go to an authority, to a private body approved, which has a license, a government license that tests the software or tests the product. And actually, the AI Act for the high-risk AI systems mostly relies on self-certification. So to clarify, it depends on the category of high-risk system. If you have safety components, we just refer to the conformity assessment. So to go back to our diagnostic software, you just follow the procedure under the medical devices regulation. They just check the AI requirements too. Fine, that's all stuff we know. When you look at the high-risk use cases, which again we're talking about decisions that impact human rights, that can really impact lives, that we wanted to have guardrails against AI-based decision-making, there is third-party assessment if you're working with a biometric system and you're not applying a harmonized standard. Is that something we're familiar with? So a biometric system, that identification, categorization, or authentication system, identification or categorization system, or emotional recognition, those are certified through third-party companies if you're not following the harmonized standard. If you're following the harmonized standard, then, and there is one, then that part is self-certifiable. Sure, that's fine. There's a procedure in place. For all other use cases, it is self-certification. But those were some pretty high-risk use cases. Why? Well, in a recital, they actually admits weakness, admits a problem they faced, that the certification bodies are technical experts and do not have human rights expertise. So because of that, because of the complexity of the matter, and simply because the expertise still needs to be developed, the AI Act states that in a first iteration, at least, as a general rule, the provider has to certify themselves. Provider, figure it out for us. And from my tone of voice, you can tell that I criticize this, because ultimately with other laws, we have had ways that we take into account step practices, and basically at least there have been an optional way of assessing by a third-party assessment, maybe through a regulatory sandbox that will happen, or through a government that will happen, but the market would have been able to find a way to efficiently certify these methods, or to find something that works. Whereas now you're just telling the provider, figure it out yourself. It can still happen, but the burden of reliability cannot be thrown away, which I think can create a lot of legal insecurity and fear. Another aspect of high-risk AI systems, what about general purpose AI systems, like your ChatGPTs, your large language models, because they can be used for anything. Well, they released ChatGPT during the negotiation, so they quickly had to create a regime for itself. And what it ultimately says is the provider of such a model needs to keep documentation, make available the capacities and limitations that they know, have a policy in place in copyright and related rights, and a summary about the content they use to train that model to scrape, except if you're using an open source model. I believe the term open source everyone's familiar with. Okay, so if you have an open source model, parameters are publicly available. Sure, you don't have to do that. Unless if your AI model is considered to have systemic risk. And systemic risk is when it can disrupt society in a certain way, which is proven by either a decision of the European Commission, or is presumed if the total amount of, which is also not a good metric, I believe, if the total amount of compute used to train and develop the model exceeds 10 to the 25th power flops. Flops is a metric of computing power. To give you an idea, DeepSeek, the Chinese ChatGPT equivalent, runs on 3 times 10 to the 24th power compute, thus not meeting that threshold, showing that this compute threshold. Why was that? Because at the time, most of these systemic risk models, they were looking at these really large models. But now these models are made smaller to run more efficient on more hardware, thus making this criterion obsolete. What do they have to do? What do providers have to do?
It's obsolete now. It's not applicable anymore. This systemic risk, this figure.
The number is no longer usable. So you have to rely on commission decision by itself. Or there will need to be a reiteration of the AI Act, because ultimately that was something that was developed at the time of the technology that wasn't mature yet. And now we're realizing that, that's a problem when you don't have technology neutral regulation. It's actually throwing the gauntlet to industry saying, please develop around me. Please circumvent me. And I think that's what can happen now. What do they need to do? Well, you need to evaluate the model according to standardized protocols, assess and mitigate systemic risks, keep track and report serious incidents, and provide an adequate level of cybersecurity protection. Harmonized standards are possible, but before that, there is a code of practice, and that was recently published, 10th of July. They published a code of practice. It doesn't provide the most clear metrics. Actually, the first draft has very clear metrics. Now that has been a bit mitigated as far as I have read it. But anyways, it is a document that several companies have signed. Not all of them. I believe Apple hasn't signed them, but there are as many AI providers that have signed these commitments and will therefore test them. Now, governments and enforcement. I received a question, Gokhan, you asked me a question about how this is going to be tested. So ultimately, what happens is when you're a provider, so either we will have national supervisory authorities. They can come from the data protection supervision. Usually they might come from the market surveillance authority. I know in Belgium, the government agreement says it's going to be the telecoms authority that will take on this function. But ultimately, member states are free to choose. And I know for them, the EU, for its institutions, chooses the European Data Protection Supervisor. And they're the market surveillance authority. They do checks. They check and they can impose sanctions. They can impose fines. Of course, when I talk about certification, a notifying authority, that's the one that gives accreditation to a conformity assessment body that is a notified body, and they issue the certificates under their own responsibility. And that's the enforcement aspect of it. At the EU level, what do you have? Well, the Commission can, of course, escalate some things upward, but also the Commission there is a new body called the European Artificial Intelligence Board, which is essentially an advisory body, much like the European Data Protection Board, that provides guidance on how to implement the Artificial Intelligence Act in a way that is harmonized across the European Union. Most of these structures are not there, so I cannot say much about them. Mm-hmm. That's for the high risk. For the rest, there's also a rule that simply, well, I can summarize this in one way. If you're using AI, you have to say, if you're marketing an AI that interacts with people, an AI that creates text, that creates deepfakes, that creates content on matters of public interest, you have to make clear it's AI. So you have to say with an AI, you're talking to an AI. You cannot say you're talking to a human. In motion recognition systems, you need to make sure that people know that they're being subject to this. The deepfake generator, you have to know this is artificial content. The content needs to be watermarked as such. AI generated content makes it really clear that AI was used to generate this news item where labels left. And again, enforcement, there are market surveillance authorities. Important, it wasn't there in the beginning because product safety law is usually a very technocratic institute where users are not really involved. Now anyone can file a complaint to the authority. So that's very interesting to see how that will go. And again, when it comes to administrative fines, well, some breaches, if you breach the banned practices, so marketing ML is banned, that's 7% of your turnover or 35 million. Other provisions, 3% or 15 million. And for incorrect and misleading information, 1% or 7,500,000. SMEs will be subjected to the lower amount. So one thing they will do is lower the burden for SMEs. Now we can go over the Cyber Resilience Act. So the AI Act, actually, like I said, does a lot of things that aren't really cybersecurity, and it's only one type of product. The Cyber Resilience Act now fixes that gap on the cybersecurity, on the product side for Cybersecurity Classic. Where are we in the timeline? Everything is still upcoming at the time, but we know that the law has been adopted, so we know what it's going to look like. And what the Cyber Resilience Act does is it is applicable to any product with a digital element. That means any hardware-based or software-based digital product that processes digital data that uses this, excluding medical devices and vehicles. Why? Because they have their own certification systems. Excluding national defense, because, again, European Union's competence doesn't stretch that far. That is marketed in the Union. I say marketed, very important, because in cybersecurity, there's one thing I haven't talked about that I now need to mention, which is open source. Mm-hmm. Because for open source, well, to those that are not familiar, open source is code that you publish the code and anyone can fix the code or change the code as they wish. And for security, people love that. I usually teach this lecture to engineers, and when I ask, do you trust a certified system over an open source system, they will always go for open source. Always. Why? Because you can see what's in the code and you can judge for yourself. The problem is if you have to certify, then a lot of these open source, which is mainly hobbyists, they can't do that. They cannot do that anymore. So what the Cyber Resilience Act is solved, and I think you can transpose some of those findings to the AI Act, is it only applies if you deploy it in a commercial activity. Commercial activity, so for example, if you post it on GitHub or Hugging Face, that's not commercial activity. You have to show that you're charging a price for it, that you're asking a fee for it, that you're taking donations with a profit, that you're doing a support fee for it, like Canonical and Ubuntu, or that you're integrating it into a commercial platform. Mm-hmm. And if you have these indicators starting from a certain scale, then you would be considered marketing it, and then the Cyber Resilience Act becomes applicable. But just releasing, for example, a distribution that you wrote by yourself, that would not be. But it creates a sort of gray zone because, of course, that means that always there's this sort of Damocles that at some moment you have to get your stuff together. You have to get your act together. And I will explain further what the rules are. What type of categories we have? Well, there's three types of categories. There's your basic product digital elements. There's important ones and critical ones. The critical ones are security boxes, smart meter gateways, smart cards, similar. What matters is though that division will influence the conformity assessment procedure for them. Here's a list of the important ones, include stuff like operating systems, smart toys, and the like.
Password managers, etc.
Yeah. So when it comes to who is employed, well, again, you have the manufacturer, much like the AI Act, import distributor, and now you have the open source security software steward. Who is that? That's actually an entity that doesn't produce but provides support and sustained basis for open source development. Think of the Python Foundation, the Linux Foundation, and the like, that simply have basis and support activities for open source developers. These are the requirements that a manufacturer has to provide. And what I see is there is a huge combination, I think, of, well, NIS, for example, with the 3-tier reporting of actively exploited vulnerabilities with the requirement to certify a vulnerability handling process for at least 5 years, cybersecurity risk assessment before you develop something. You assess the cybersecurity risks either way, that you report a vulnerability to the manufacturer down up the supply chain, provide updates, provide security. It's a very detailed, very large list of obligations that partially combines and partially redoubles.
We had this 3-tier reporting process before. How about the time frames? Are they similar or are they identical with?
Not identical, but similar. So when you look for the significant incidents, that timeline is equal to NIS2. But but the only difference is that under Cyber Resilience Act is the manufacturer of a product. It would be Dell, for example. Whereas for NIS2, if you're using it, that's for the user. But for actively exploited vulnerability, that's essentially when you discover that there's a gap in your system that someone is actually using to attack the system, then the only thing is the final report has to be submitted within 14 days rather than 1 month. And there is a reporting platform that ENISA will create. And the steward, what they have to do is they simply have to have a policy in there and cooperate. And the policy essentially includes voluntary reporting, a policy to develop that allows the open source developers to make sure their product is secure. Presumption of conformity. This is pretty much same old for any product safety law. Again, a harmonized standard, common specification, or a certification scheme under the Cybersecurity Act. What type of certification? Well, for most basic products, you can follow an internal control procedure that provides self-certification, or three types of third-party certification. Starting from importance, you can only use third-party certification. So get this, Microsoft, Canonical, that releases the Ubuntu operating system, need to undergo third-party conformity assessment before they can provide a new release. That, because with other distributions, for example, depends on whether or not on how professional they are. So you can imagine the compliance burden that it would have on using these distributions, which can be good too, because you're ensured that there's features, but at the same time, the open source spirit is also a bit harmed. You have to get your act together at some point. And for example, when you start a project, either you will become a steward or you will become a manufacturer starting a certain scale. Enforcement, again, market surveillance, again, sanctions. I can go with this. And with this, I can conclude my bird's eye overview and just come back to the same AI generated slide that there's a lot of laws. I know, it's a lot. And it creates a fear in the European Union. In 2024, Mario Draghi published his competitiveness report saying that through governance, that in the EU, there are so many different requirements regarding how to set up a certain market that are differently implemented in different countries, that are differently understood in different EU countries, that it's very fragmented, creates a lot of legal insecurity. And especially this wave of new laws that keeps coming has a similar effect, that it's just difficult to keep up and creates a lot of overhead and creates business. And the EU is aware of this. They now have this omnibus package that they propose that they will try to some degree to reduce that burden. But ultimately, there is a huge fear. I also would like to mitigate that fear with these because ultimately, with these two pictures, well, I think these two pictures, I'll give you my full opinion on this. On the left, you see, well, I think in Turkish, they call him bilgiçirin. And actually, that's a mistranslation. Because in the original French, it's Schtroumpf à lunettes, gözlüklü şirin. because he thinks people might call him smart. He's not smart. He just wears glasses. He thinks he's smart. And when he's an insufferable know-it-all that sometimes gets kicked out of the village for being so. And the EU can be that, in the sense that when you have all these laws on an industry that's not even their own, most of the industry is in other countries, in different countries like China or the United States, then ultimately it's always pointing the finger. But at the same time, we don't know if it is, well, and indeed there is that with all these rules, you will not get much done. It might not be properly implemented. There are so many details that things can just go completely wrong, creating a huge compliance burden that simply is a heavy weight on the industry that it cannot develop. But I also want to mitigate that, because a lot of these rules, yes, there's a lot, but they actually follow a similar mechanism, and they follow similar principles, and they follow similar practices. And you can actually, they overlap a lot, but that can be a weakness or a strength, because that also means you can use one process to cover many of them. And again, much of the details will be, for example, in what the harmonized standards will look like, whether they will actually work, whether those metrics will actually do what they're supposed to do, whether the conformity assessment procedures actually are effective, and whether they're efficient. In other words, for example, let's say if you have a conformity assessment procedure that's 10,000 euros, if you have an open source methodology that you can actually do it for a lower cost and get a similar result, these details matter. And what I will say about security by design in the EU, it's very good that we're having regulations. It's very good that we're requiring this across the supply chain. And how ultimately it will depend on the details being worked out right now. And in that sense, all I can say right now is the proof of the pudding is in the eating, and it hasn't even been served. And with that, I can conclude my presentation. Thanks very much for your attention. And if there's any questions, please ask. Fire away.
Yeah, you should mute yourself, then I will turn on my voice.
Yes, just a second. Why is this not working?
Thank you, Koen VRANCKAERT. That was a bombardment of very essential information. I think we had to redo this, because we're going to see the effects of this. I mean, these upcoming 2-3 years are of critical importance. That's what I get from this. And exactly, sometimes less is more, and we have definitely a plethora of regulations here, but I'm optimistic as to this, as to the practice, the compliance, but on behalf of the actors in the sector, because it has been achieved before by GDPR. So I think it's going to be doable, definitely doable for the EU to impose these standards, and they'll be accepted by the actors in the field. That said, but again, still I have my doubts, especially in terms of its effect upon the public stewards. I think they're going to be pushed to be more market oriented and more profitable in terms of being marketed, or not. I mean, this is my question. Are these companies going to be induced to be more market oriented, or what do you think about this?
Well,
Python, Linux.
First of all, so you're talking about the open source.
Exactly.
Okay.
You
So
turn on your voice.
yeah, I turned it on just now. So, well, first of all, before answering that question, I will also say with the GDPR, yes, true that it's already been done before, but implementation report later down the line did mention that the GDPR is unevenly implemented and also misses its mark in many places. For example, there is a big reason that a lot of big tech companies set up shop in Ireland, because the Data Protection Commission ultimately dealt with 99% of its case law by simply removing it and not dealing with it at all. They actually were sanctioned for
But
that.
that was a coincidence that these were established in Ireland.
Actually, no, it was
Microsoft. That's it.
no, that was intentional. No, that was very intentional. That was very much form shopping. But yes, but it has been done in a way. But ultimately, how often can you repeat this process? I think that's something to think about. How often can you repeat this process and rely on the Brussels effect before the Brussels effect, people turn against the Brussels effect? That hence the Bill cheating metaphor. Basically, how often can you be the smart guy without getting kicked out of the room?
Exactly.
But to answer what the open source software standard stewards will have, what the open source stewards will have to do, well, ultimately what they have to do is they have to provide a policy that ensures a certain level of security. Does that mean they will have to be more market oriented? I think they will be required to provide more documentation that allows users to be more market oriented and already have things in place to reduce technical debts before they can go to market. That I think will definitely be the case. By cooperating with market surveillance authorities, it is also not necessarily clear to me what role they will play. It's possible that they will have to play a more active role as certain users will have certain scale. It's possible that they will have a more passive role because, for example, with support, what type of support are we talking about? It could be support with how to ensure interoperability. Sure, that there's a policy in that in place there, that's fine, I guess. As long as their operations can handle it. Because one thing that I am worried about with the Cyber Resilience Act, open source can still survive, but a lot of open source projects are purely volunteer based. And then I think indeed the costs may increase. I wish I could say in what direction, but I know that it may indeed increase. And also, what about, for example, these development programs that are just community based? So for example, I like to take Linux distributions, and I know this might be too technical for some lawyers, but I like to use them as an example because, for example, in IT, if you're using Windows, sure, that's very much a company running it. Let's say I want to get into Linux and I run Ubuntu. Ubuntu is released by a UK company, so that's still very much a manufacturer. But then you go into distributions like Mint, or God forbid, some Uber nerds will know this, Arch. Those are purely community-led, developed by a group of volunteers because they want to. They're very much a Wikipedia of operating systems. Well, depending on how professional that's considered in their business model, they would have to provide certain security features, yes or no. And that also will impact the organization of foundations that provide code basis for these distributions. So in that sense, you can imagine that based on how things are organized, yes, we will have to, there will be a push towards more professionalization, depending on the intention of the product, because it's also not for every product. For example, important products are only a subset. It's for all digital products, but not everything for others. Self-certification is not as always better, but cheaper. So yes, it will likely increase costs, but in what direction, it's at this moment difficult to predict, I'm afraid. Does it mean that we will have to be more market-oriented and business-oriented? Perhaps, but to what extent? That is currently
to be seen.
Yeah, exactly.
Betty has two questions, and the first one I think we will have for the first one, or you may also read and pick your question. Number one is, let me read. To what extent can algorithmic tools or AI-supported flagging meet the DSA's requirements of diligence, objectivity, and accuracy? This is the first question. You want to go on?
Sure. So to what extent can algorithmic tools? So I suppose you're talking about, AI content moderation or flagging tools that meet how can they meet that? I think that is still something to be determined in standardization as well. I believe, as far as I understand, that pure content moderation is not a high-risk AI system. So in that use case, there is actually no requirement based on the Artificial Intelligence Act in terms of bias, in terms of certification. So in that sense, there is no certification mechanism at the time. To what extent can they meet? I think that's a question that indeed many have not been able to answer, because ultimately a lot of these AI tools are very context unaware. And the problem of social media is indeed that it's very difficult to infer a proper context. That's why we're often using humans in certain countries, and even that I think is highly imperfect. I also have my concerns regarding whether AI-supported flagging can meet the requirements of diligence, objectivity, accuracy in full. Probably what you'll have is there is a combination of humans and AI, but even then I think it's still meeting it. So to what extent can they meet them by themselves? I don't think so. Without certification, perhaps in the future, but I'm also quite skeptical at this moment of technical maturity and oversight. I hope that governance solutions will be developed in the future. I just know that the AI Act, based on how it's currently set up, will not provide that level of accuracy. All it can do is simply flag something as AI, and even that is imperfect because it would use certain words. For example, I think there was even that ChatGPT that there was an algorithm that detected AI-generated content based on the use of a certain sign, which I use in my writings a lot, which are even when they're human-made. I mean, and then I hope that answers your first question. When it comes to your second question, how can the governance model of trusted flaggers be aligned with broader cybersecurity frameworks and data protection norms? Okay, so ultimately, I think there are several ways to do that. but I understand because I'm also doing research into further alignment of those. First of all, with data protection norms. So let's say you have trusted flaggers. Well, these are entities that potentially post or can flag content and that have a certain label. And what you can do is you can simply communicate to users that you have this type of framework in place to comply with a legal obligation. And because that's an acceptable purpose, or if that doesn't work, you can use legitimate purpose. I think legal obligation would be better. You have to limit yourself to what's necessity. For more, you could use legitimate purpose to do your own business. And or consent of the data subject for really pernicious types of processing, that they provide their data to that. But ultimately, there is a process that you can simply have that some data is sent to a trusted flagger that then sees it on a need-to-know basis, perhaps anonymized, that they don't see who posted, but they just see the post and they can see the other contents, and that they can then flag. And then that way you can implement the corresponding article of the Digital Services Act in a matter that complies with the General Data Protection Regulation. Doesn't mean it will perfectly comply with right to privacy, but that's a good proxy at the moment, because privacy is different than that. But still, it would be a good proxy, I think, mostly through giving those flaggers and anonymized tools, I think would be a corporate housekeeping way of doing it. When it comes to broader cybersecurity norms, well, I think one thing you have to understand is cybersecurity and the Digital Services Act are two different things. So the Digital Services Act is there to regulate social media platforms. And yes, it comes from the e-commerce directive and how much they are responsible for illegal content, illegal stuff that is circulated on social media, breaking, for example, child sex abuse laws or other content restrictions that are applicable. But it does not by itself govern social engineering attacks such as cyber attacks that are meant and that were classically intended to protect machines from malfunction induced by illegitimate users. So in that sense, they used to be a silo that reduces the need for a particular alignment of that. So your trusted flaggers, they operate in a secure infrastructure, and that is fine. I think the only conflict there would be when you start treating the things that trusted flaggers have to do, like social media post-breaking content policies, with cybersecurity attacks. And I know that is there. There is one particular subset of potential attacks that particularly targets that is disinformation attacks, because what we're seeing is that ENISA qualifies that as a cyber threat, not necessarily a classical cyber attack, but it's considered a cyber threat because of its similarities to social engineering. And in that sense, yes, there might be an overlap, but at this moment, how it can be aligned, I think further research is necessary on that for that particular use case. But for the most part, I think the alignment of trusted flaggers that simply flag certain posts or content as breaking the law doesn't necessarily correspond to detecting a cyber attack, and they would be dealt with as separate things. So I hope that answers your question. If there's any further questions, you can always ask again, or you can we can bilaterally sync. You can also send me an email for that, because I would love to talk more about that.
That was a very detailed reply, actually, as a matter of fact. But there's definitely further need, and we have some real-time questions, I guess.
Okay. There are no stupid questions.
But yeah, I feel like I'm a stranger to the topic actually, but more of a theoretical one. Sometimes I used to work for the Ministry of Foreign Affairs also, and there we were for some such regulations, and I graduated law school, and that's it, like, probably I have no idea about this area of work. And sometimes I get this feeling that governments and lawmaking, like we all have this is something we learn in school, so that it is kind of like heavy-handed, slower. And this is an area that moves really fast. And not only its speed, but it's also velocity is increasing as time goes on. So I get this feeling that sometimes we will never be able to catch up with the speed of the industry and real life, and it will get to a point where it handles up so badly that this would be so much harder to fix it. As someone from inside the topic. What are your thoughts in fact, as the two questions debate?
Thank you for your question. I agree and disagree with you at the same
Maybe
time.
repeat the question.
So to repeat to those online, so ultimately what the question is that technology is developing so fast and different use cases are developing so fast and the law is always just behind. So any legal change, people are trying to regulate this frantically, but ultimately because the technology is also immature, that it's very difficult to see where it will go, that it's impossible to properly regulate, and that ultimately all you're creating is a bunch of technical debt and a bunch of compliance burdens that will lead you nowhere. And ultimately you'll always just be behind. So why even, if I understand even why even bother at some point?
Are we ever going to be?
Are we ever going to be
close the-
capable?
Close this gap? Are we going to be Luddites for the?
I think, well, I think I have an intermediate position here because when it comes to can the law fully catch up with technology? No, it never could. That by design, because law regulates things that exist, whereas innovation by its verb, by the meaning of the word, does not exist. So of course you have these but the problem is, what are you trying to regulate with the law? You're trying to regulate in a micromanaging, heavy-handed manner any type of regulation, new technology, then in my opinion, you would be doing bad regulation. Because there is a book written in 1980 by David Collingridge, and he described it as the Collingridge dilemma. So whenever you have a new disruptive technology, you always face the dilemma of, do I regulate it now, not knowing what the risks are and possibly pushing it in a very, very wrong direction? Or do I regulate later when a technology has become so entrenched that I can no longer do without and I'm now dependent? So I think that's the dilemma. I think when I hear your question, that's the dilemma I'm hearing. And it is something that we're all trying to solve right now. And there are different answers in different countries. For example, the US has a very, very anti-regulatory stance. And China, and I know there are other countries that actually have a very, very regulatory stance. The EU tries to provide regulation by creating edicts and standards and the likes, but China, for example, is also doing that by even cracking down on tech businesses because they weren't following the party line. I'm not advocating for either of these models, by the way, for the purpose of this question. I have my opinions, but that's not the point. That's the point of my reply. But the question is, how do you follow this? Well, ultimately, the question is, where do you lay your focus when regulating? Because if you're always, because the problem of bad regulations piling up is when you're always focusing on the new shiny thing. Because the new shiny thing is shiny and new because it was just released, but you don't know what it's going to be. You don't know what it's going to be in the end. There's always a hype curve. Things hype up, then all of a sudden we realize the backlash that nobody wants to use anymore, looking at generative AI. And then at some point, people start slowly picking it up again and taking it for what it was. And I think regulators have to be aware of, and regulators and lawmakers have to be aware of this tendency with technology, because in my opinion, what laws do is focus on create a framework focusing on the principles that do not change. So for example, let's say privacy regulation, GDPR. The basis to have a right to privacy of citizens hasn't changed since the Magna Carta. The governments should leave people alone in their homes. It just has a different expression, slightly. Same thing with safety. The idea of you want your product to be built in a safe manner so it doesn't explode on you while you're using it, so it does what it's supposed to do, is not new. Does that make sense? And in that sense, for example, the civil code, I know Belgium only recently is still using parts of the Code Napoleon. That's a legal act of 1804. But yes, we're now reforming and codifying because there were changes, but we were trucking along just nicely with it. Why? Because then you have a framework for civil transactions, but those needs have not entirely changed. And I think that's something that regulators, I think that is maybe a way out of your dilemma, I think, because the dilemma with speed, yes, technology is evolving at an extremely rapid pace, and it's very difficult to even develop social norms. But ultimately, when you look at generative AI, well, my parents are baby boomers. They saw the development from typewriters and writing paper to the computer, to the internet, to where we are now. So every time, and actually very often you didn't always have to reinvent the rule book. It just was another way to read, another way to write, another way to work. And yes, there are potential risks and the likes, but in that sense, I think when a good regulator is technology neutral, that's also why these definitions in EU laws, they try to be as technology neutral as possible. Because if you have a too detailed regulation, well, first of all, the industry will find a way to work around it. And you will not meet the mark. That's Goodhart's law. Any metric that becomes the purpose stops being a good metric. And either way creates a compliance burdens for the legitimate use cases. That's why you have to be neutral. So it applies across time. And maybe we're not doing that enough. I'm not denying, I'm not saying anyway in that, because I cannot say that right now. But I think the main answer to your dilemma as a regulator would be, don't focus on the things, on the shiny new thing. Focus on the foundation. Focus on the foundation that's underneath and what are there and the changes that are occurring over there. And that's where the law needs to step in. Nowhere else.
Thank you, Koen. And that was a very interesting question. Nilüfer also thanks Koen for this illuminating presentation. It was a lecture. I think we all enjoyed and we got a lot from this, learned a lot. And we have maybe more questions now, by the way, before this lecture. Thank you. That was thought-provoking, and we have now at least the actual information, and where we stand is now reminiscent of actual, let's say, in terms of EU and its cybersecurity laws, I would say.
Yeah.
I cannot thank you enough for this, and hoping to redo this again in a very short time.
Likewise.
Take care, everyone.
Thank you so much for having me.
That
Thank you so much. Take care.
awesome.